All right. Welcome back to my very first not live video. Still using StreamYards though. As I mentioned, I've been temporarily evicted from my normal studio space, also known as the guest room, until slightly after Christmas. Well, slightly after New Year's. So I don't trust the Wi-Fi in this room as much, so I'm just recording and then posting. So after what had been a flurry of postings in the DeCastro versus Abrams et al., we went through almost a week with nothing. Quite abnormal. So today, though, we got Josh Abrams, Joshua Garrick for Josh Abrams, filing the opposition to plaintiff's motion to dismiss counterclaims. This is very good. I really like how Mr. Garrick wrote this. I like his arguments, partially because you add his legal citations, and it's pretty much the same arguments that I made in my last video. Imagine that. So, with that, let's just jump right in, since I don't have to wait for people to show up. Joshua Abrams' opposition to plaintiff's motion to dismiss counterclaims. Section 1, preliminary statement. Now comes defendant Joshua Abrams, a.k.a. Accountability for All, Abrams, who respectfully opposes plaintiff Jose Maria de Castro, a.k.a. Chili de Castro, a.k.a. Delete Lawz, a.k.a. Delete Lawz, de Castro, motion to dismiss Abrams' counterclaims. In his motion, de Castro levies a laundry list of reasons for dismissal. I like that. For those of you who have seen the now settled appellate briefs in the Depp v. Heard, Ben Chu, Johnny's lead attorney, in opposing the admissibility even of the amicus briefs for Amber, he opened, this is a kitchen sink appeal. I liked that. The laundry list of reasons for dismissal is slightly below kitchen sink appeal, but still very good. However, each such argument is either baseless or undeveloped in a way that it fails to adequately put Abrams and the court on notice of the reasons for dismissal. In all instances, de Castro's motion should be denied. Procedural and factual background. On September 2nd, 2022, de Castro filed a lawsuit against Abrams and co-defendant Kate Peter, a.k.a. Masshole Troll Mafia, Peter, alleging defamation-based claims, including defamation and intentional infliction of emotional distress. See Complaint for Defamation, ECF number 1, hereinafter referred to as the complaint. These claims purport to be predicated on statements made by Abrams and Peter on various YouTube channels during ongoing debate and argument between the parties. See the complaint. On November 7th, 2022, Abrams answered de Castro's complaint, as did Peter, same day, and answered de Castro's complaint and counterclaimed, it should say counterclaimed, against de Castro for various defamatory statements de Castro made about Abrams on YouTube. See Joshua Abrams, answer, jury demand, affirmative defenses, and counterclaims, ECF number 53. hereinafter referred to as Abrams counterclaims. 2 days later, DeCastro docketed a letter with the court claiming that he had intended to dismiss his complaint without prejudice. See ECF number 55. See also ECF numbers 56, 58, 59, 60, 66, 73, 80, 82, and 83, seeking similar relief. If he's one thing, he's a broken record. In each instance, citing to Federal Rule of Civil Procedure 41, and recognizing that both Abrams and Peter had answered the complaint and filed counterclaims, the court could not dismiss the lawsuit without consent of all parties. C.e.g. ECF number 50, numbers 57, 67, 74, 81, and 85. See also ECF number 64, Abrams and Peter declining to consent to dismissal. Acknowledging that the litigation was going to continue, DeCastro has now moved to dismiss the counterclaims filed both by Abrams and by Peter. With respect to Abrams, his counterclaims identified several defamatory statements DeCastro made about Abrams. This included statements accusing Abrams of being a rapist, an attempted rapist, accusing Abrams of going to prison for raping his girlfriend and beating up his father. See counterclaims at paragraph 14. Abrams identified 4 YouTube videos that contained these defamatory statements. In addition, Abrams referenced other defamatory statements made on websites, chats, and webcasts, including those statements made through DeCastro's YouTube channels, Delete Lawz, and his backup channel called Chili's Backup, which, despite the order to preserve all evidence, has been deleted. Whether by YouTube or by Delete Lawz, I don't know. These defamatory statements were false. They were made with knowledge of its falsity or reckless disregard of its truth or falsity. They were made with actual malice, and they were designed to hold Abrams up to scorn, hatred, ridicule, or contempt in the minds of considerable and respectable segments of the community. Once again, he's laid out. Those are the elements for a defamation claim. Abrams filed a 1-count counterclaim for defamation, given the financial damages, emotional distress, and anguish suffered as a result of DeCastro's statements. On November 16, 2022, after Abrams filed his counterclaims, DeCastro amended his complaint to raise allegations of copyright infringement based on Abrams' alleged unauthorized use of DeCastro's YouTube videos on his own channels. See First Amended Complaint, ECF number 62, with the footnote. DeCastro then filed a supplement complaint to add YouTube as a defendant, rather foolishly. The sole count of the First Amended Complaint is a claim for copyright infringement pursuant to Federal Statute 17 U.S.C. Sections 501, etc. See with footnote 2. Now, I really like this footnote. It's long, but it throws a lot of shade. It appears that DeCastro, in amending his complaint, has abandoned the defamation-based causes of action in favor of his newly minted copyright infringement claims. Abrams is wary that DeCastro has done this intentionally so that he could do an end run around this court's orders, declining to accept his belatedly filed notice of voluntary dismissal of the defamation-based claims. That is a good concern. It's a valid concern. I fully suspect that's the reason he's done that. Abrams' concern is that DeCastro may refile the defamation cause of action in a California court, a venue that lacks personal jurisdiction over Abrams, a Massachusetts resident with insufficient ties to California. The California court should nonetheless dismiss such a refiled claim, not only for a lack of personal jurisdiction, but also under the doctrine against claim splitting, which precludes a litigant from strategically pursuing in a subsequent suit claims which were or could have been brought against the original defendant in the original suit. It means bring everything now or don't bring it. That's what the prohibition against claim splitting is. If you want to sue for copyright infringement and for defamation based on the same videos, do it in the same case or don't do it at all. And that cites Airframe Systems Inc. versus Raytheon. See also Mendoza versus Amalgamated Transit Union. The Raytheon case is First Circuit. Mendoza is a Ninth Circuit. While such a subsequently filed claim would be promptly dismissed, Abrams recognizes that DeCastro has brazenly admitted that his goals in pursuing litigation against Abrams and Peter is not to win, but to vex. See ECF number 71 at 1. So this was in Kate's motion for sanctions, motion for contempt against Delete Lawz. Line 1, the header of the entire motion. Benjamin Wish wrote this. A direct quote, of course, of Delete Lawz from one of his videos. I will break them financially. They will have to hire a lawyer. I will file motion after motion after, and I'll just keep going legally after them until I break them, until they can't afford to hire a lawyer anymore, so they run out of money. That's what I'm going to do. I'm going to break them. So I like that Mr. Garrick has brought this quote again, because the more the judge sees it, Delete Lawz has complained, oh, Judge Burroughs, she's prejudiced against me. She doesn't like that I'm conservative, and she's clearly liberal because she was appointed by President Obama and, confirmed by a majority Republican Senate, might I add. But, let's not let facts get in the way. But yeah, they're trying to prejudice her against him. And repeating this quote as often as they have a legitimate reason to do so, it's good lawyering. Such improper and ulterior motives warrants this court's attention here to avoid future abuse and harassment. Accordingly, I like this. Accordingly, Abrams will agree to give DeCastro one final chance to replead the defamation cause of action in a third amended complaint with Abrams' assent, so long as it is requested within 10 days of receiving Abrams' forthcoming motion to dismiss the second amended complaint. Should DeCastro decline the invitation, Abrams asks that this court, there's an extra 2 in there, but asks this court to rule that the defamation-based claims raised in the original complaint are dismissed with prejudice and reject any further attempts by DeCastro to amend the complaint as futile, unduly prejudicial, in bad faith, and in furtherance of DeCastro's documented dilatory motives, citing Foman versus Davis. So I like that. It's, remember, as a right, the plaintiff can file a first amended complaint as a right. After that, they have to ask permission. And so here, Mr. Garrick says, Josh is willing to let you file one more amended complaint, to add this charge again, to bring the defamation cause of action back into this court case. And the reason is, it's not that he wants to defend himself for this. It's because he wants finality. Either way, he wants it dismissed with prejudice. And whether the judge takes it as Delete Lawz has done an end round to dismiss the claim and says, all right, well, that's done with prejudice, or if he refiles it and then Josh files a 12b6 motion to dismiss for failure to state a claim, or for a summary judgment so that it's actually decided on its merits. He wants finality. So this may seem kind of counterintuitive, but I like that they're doing this. On December 8th, 2022, DeCastro moved to dismiss Abrams' counterclaims. See plaintiff's motion to dismiss the counterclaims, ECF number 86. Although the arguments are undeveloped, he seems to merely state a list of Rule 12b defenses, including dismissal pursuant to Federal Rule of Civil Procedure 12b1, lack of subject matter jurisdiction, 12b2, lack of personal jurisdiction, 12b4, insufficient process, and 12b6, failure to state a colorable claim for relief. Each of these bases for dismissal can be disposed of in short order, as none of them are remotely meritorious. Accordingly, DeCastro's motion should be denied. And on to the arguments. This court has original subject matter jurisdiction over Abrams' counterclaims. If you remember, in Delete Lawz' motion to dismiss, he says, well, the court doesn't really have jurisdiction over this claim, and because it's a state law claim, you can't exercise supplemental jurisdiction. I already discussed pretty much these same reasons for why that's a nonsense argument. DeCastro's first basis for dismissal should be denied out of hand, as the court clearly has subject matter jurisdiction over Abrams' counterclaims. This court has jurisdiction to hear state law claims where the parties are diverse, meaning different states, different domicile states, and the amount in controversy exceeds $75,000. See 28 U.S.C. 1332A. That's the statute for diversity jurisdiction. Abrams and Peter are both citizens of Massachusetts. DeCastro is a citizen of California, and the amount in controversy exceeds $75,000. See the counterclaims. Indeed, given the nature of the defamation-based counterclaims, seeking actual damages for loss of revenues due to declining YouTube viewership and membership, as well as emotional distress and mental anguish, arises out of DeCastro's repeated defamatory comments about rape and domestic violence. Pleading damages in excess of $75,000 is certainly plausible and made in good faith. Under these circumstances, the amount in controversy pled in the counterclaim controls. See Esquian Mendoza versus Don King Productions, Inc., First Circuit 2011, stating, the amount specified by the plaintiff controls as long as that amount is asserted in good faith. A court can dismiss an action for insufficiency of the amount in controversy only when, from the face of the pleadings, it is apparent to a legal certainty that the plaintiff never was entitled to recover a sum equal to or in excess of the jurisdictional minimum. Accordingly, the court has subject matter jurisdiction over Abrams' counterclaims. So here, Abrams has asserted that this has caused at least $75,000, the jurisdictional minimum, of damage. He doesn't have to quantify what those damages are. Now, the court could find after trial, yes, you were damaged, but we find you were only damaged by $20,000. And then, oh, hold on, that's less than $75,000. So this needs to be reversed on appeal. But that's not the case, because as long as Josh can say, I'm making a good faith estimate that at least $75,000. So let's say I'm in a car accident with a resident of Colorado, so I sue in federal court. Now, I have no medical bills. The only thing I'm suing for is damage to my car. And it's $20,000 worth of damage. I can't assert, you know what? Yeah, I had my car fixed for $20,000 or even replaced for $50,000. But they really caused $75,000 worth of damage. So I deserve to be in federal court. So that would be dismissed. But let's say I plead, my car suffered $50,000 worth of damage, and I was without my car for an undetermined period of time, causing me to lose income because I needed my car for work. And I believe that amount to be in excess of $25,000. I don't have to quantify that $25,000 in the complaint. I just have to allege it in good faith. That puts me over the statutory minimum, the jurisdictional minimum. So that's what Josh is doing here. So he's done it in good faith. Delete Lawz hasn't shown, well, there's no way he can possibly be claiming $75,000 of damages in good faith. So as of now, the court has subject matter jurisdiction based on diversity of citizenship. But Mr. Garrick, being an excellent attorney, does not stop there. De Castro's motion does not seem to address whether the court has subject matter jurisdiction under the diversity of citizens statute and instead focuses on supplemental jurisdiction. However, the court need not address supplemental jurisdiction if, as here, the counterclaims have original jurisdiction under 28 U.S.C. 1332 in the first instance. That's diversity. For that reason, the motion should be denied. Even if the court determined that original jurisdiction was lacking under 1332's diversity, the court would still have supplemental jurisdiction to hear Abrams' counterclaim under 28 U.S.C. 1367A. That's the supplemental. The counterclaims are so related to claims in the action within its original jurisdiction that courts have interpreted this so related to language to encompass claims that share a common nucleus of operative fact with the claims over which there is jurisdiction or are such that they would ordinarily be expected to be tried in one judicial proceeding, citing Allstate Interiors and Exteriors Inc. versus Stone Street Construction, First Circuit 2013, which was quoting Penobscot Indian Nation versus Key Bank of Maine from 1997. In this case, both parties alleged various statements made in ongoing back and forth debates and arguments over YouTube channels were defamatory. It is this common nucleus of facts that makes the claims and counterclaims related. To get around this, DeCastro seemingly asks this court to invoke its discretion to decline supplemental jurisdiction pursuant to 28 U.S.C. 1367 C2 because the state law claims, according to him, purportedly dominate over the original federal claims. This argument is undeveloped, as it does not put Abrams or the court on notice as to how DeCastro believes this to be true. DeCastro fails to recognize that his state law defamation claims, where he invoked subject matter jurisdiction, are no different than Abrams' state law defamation claims, as I said repeatedly. Accordingly, it is hard to take DeCastro's claim of predominance seriously when the claims were essentially the same. But this inquiry is irrelevant because the court has original jurisdiction under diversity, and the court cannot decline jurisdiction under supplemental jurisdiction. So, if I have one quibble here, I like that Mr. Garrick said, this is all the same nucleus of operative facts. It's debate and argument in a series of ongoing YouTube videos. And that causes the basis of the defamation claims. I would have also included, furthermore, the copyright claims correspond to the same YouTube videos. So, in essence, saying even if Delete Lawz doesn't have a defamation claim ongoing anymore, his copyright claim is still a common nucleus of operative facts and evidence as Josh's defamation claim. Now, this one's short and sweet. This court has personal jurisdiction over DeCastro. DeCastro next seeks dismissal for lack of personal jurisdiction. See 12b2. The court can make quick work of this because a plaintiff consents to the personal jurisdiction of a court by bringing suit in that court, citing Driscoll versus McCann from the District of Massachusetts in 2020, and a bunch of other citations. It's really that simple. You file suit in a court, that court has personal jurisdiction over you to hear all related claims. It's that easy. I mean, look back once again. Look at the Depp versus Heard. I realize it's in state court, but it's the same principle, if not the same operative law. Johnny Depp filed in state court in Virginia against Amber Heard. Neither of them were residents of Virginia, but because he sought the protections of the Court of Virginia to sue Amber Heard, he consented to jurisdiction for Amber Heard's counterclaims against him. It's just that simple. On to 12b4. There was no insufficiency of process. DeCastro also seeks dismissal under the seldom invoked Federal Rule of Civil Procedure 12b4 defense, claiming insufficient process. I like that. I mean, does adding the under the seldom invoked, does that add anything substantive? No. Is it throwing shade? Yeah. Is it in furtherance of, this is a kitchen sink appeal, that this is a laundry list of complaints? Yeah. This defense challenges the contents of the summons. See Connolly versus Shaw's Supermarkets, Inc., District of Massachusetts, 2018. This defense fails because as a counterclaim, there was no summons and there was no service of process. Instead, Service of Abrams' counterclaims was completed by sending it to a registered user by filing it with the court's electronic filing system, the ECF. See Federal Rule of Civil Procedure 5B2E. DeCastro requested, and was granted, access to the court's electronic filing system at the status conference. Held on October 24th, 2022. ECF 44. Therefore, service of the counterclaims was proper and no summons ever issued. Now, I skipped a footnote, which was at the end of the personal jurisdiction section. By amending the complaint and abandoning the defamation-based causes of action in favor of the copyright infringement causes of action, that would have the effect of changing the court's original basis for jurisdiction from diversity jurisdiction pursuant to 28 U.S.C. 1332 to federal question jurisdiction pursuant to 28 U.S.C. 1331. This does not affect the analysis as to whether the court has subject matter jurisdiction over Abrams' counterclaims. These counterclaims still have original diversity jurisdiction for the reasons stated above, and DeCastro has failed to articulate any sound argument as to why diversity jurisdiction is lacking, why supplemental jurisdiction is lacking, or why the court should decline to exercise supplemental jurisdiction given the claims raised in either the first or second amended complaint. But once again, I would add, this is now federal question. All claims brought by Delete Lawz are currently federal question, but supplemental, it would still work because it arises out of the same facts or occurrences. And then footnote 4 at the end of the insufficient process. DeCastro also made reference to Local Rule 40.1 G5, claiming a failure to identify a related case. This rule places an obligation on the plaintiff, i.e. DeCastro, filing an initial pleading, not a defendant filing a counterclaim. Even so, Abrams knows of no such related cases. That's just ridiculous on Delete Lawz' part. And then finally, number 6. Well, paragraph 6. Massachusetts defamation law applies. Because remember, Delete Lawz said, I demand to be tried based on California's defamation laws. He can demand till his face turns blue. He's not entitled to it on the counterclaims. If he repleads his counts against Kate and Josh, California law would probably control in that case, on those claims. Finally, DeCastro challenges the merits of Abrams' counterclaims on one simple point. DeCastro claims that the counterclaims do not articulate which state law applies. DeCastro cites no case law that stands for the proposition that a claimant must identify the substantive state law that the court should apply at the motion to dismiss stage. Nevertheless, the answer to DeCastro's question is readily apparent. Where a statement was published nationally, the law of the state where the defamed party, that would be Abrams in this case, was domiciled at the time of publication applies. See Green versus Cosby, District of Massachusetts, 2015. And yes, it is that Cosby who opened himself up to a lot of defamation because when he was accused of his sexual crimes, he called his alleged victims liars. And they said, "You calling me a liar is defamation. Here's a lawsuit." They lived in California, but Massachusetts applied because Bill Cosby lived in Massachusetts. Or other way around. Green lived in Massachusetts, the defamed party. I think Merb discussed that case a couple months ago. I may be misremembering. It might have actually been Emily D. Baker or Law and Lumber discussing the Cosby case. And that also quotes the restatement second of Conflict of Laws, section 150 sub 2 and comment B. Given this well-settled principle, it is quite evident from the text of the counterclaims that Massachusetts law applies. Abrams pled that he was a resident of Massachusetts, and that the defamatory statements were published on YouTube channels, thus nationally. These facts give the necessary inference that Massachusetts defamation law applies. DeCastro does not articulate any other basis for dismissal pursuant to Rule 12b-6, other than baldly making undeveloped arguments about an alleged failure to identify the requisite elements of a viable defamation case under Massachusetts law, which, once again, that's a mouthful. Delete Lawz says, "Well, you haven't said what you're suing me for, therefore you can't sue me." But in the counterclaim, at the top of this motion, and right here in the next sentence, Mr. Garrick has laid out the elements of a defamation cause of action in the state of Massachusetts. Abrams declines to guess what specific issues DeCastro has with the defamation cause of action, and this court need not consider such undeveloped arguments. Citing CF Vargas Colon versus Fundación Damas, Inc., First Circuit, 2017. Woefully undeveloped arguments are deemed waived. In any event, Massachusetts law simply requires the following elements be pled in a defamation cause of action. These are the elements of a defamation cause of action that, for at least the third time, laid out by Mr. Garrick. 1, a false statement of and concerning Abrams. 2, the statement could damage Abrams' reputation in the community. 3, DeCastro was at fault in making the statement. And 4, the statement caused economic harm or is actionable without proof of economic loss. That would be defamation per se. That cites Albright versus Morton, District of Massachusetts, 2004, affirmed. It's just a string of citations because this is well settled. This is the cause of action. These are the elements of that cause of action. Here, Abrams cited several statements that DeCastro made accusing him of being a rapist or engaging in domestic violence. These statements were false, yet published by DeCastro nonetheless. Given the atrocity of the false statements made by DeCastro, the defamatory statements were designed to cause and have caused damage to Abrams' reputation. Finally, Abrams pled that he was financially harmed through a loss of membership and viewership of his YouTube channel, as well as emotional distress and anguish. While unclear what issues DeCastro has with Abrams' counterclaims, other than DeCastro's failure to recognize that this is a claim that applies Massachusetts defamation law, it is clear that Abrams has sufficiently pled each element of the defamation cause of action and the motion should be denied. Conclusion. The defamation cause of action Abrams filed against DeCastro is a viable counterclaim, and none of the defenses raised by DeCastro justified dismissal. DeCastro's motion to dismiss Abrams' counterclaims should accordingly be denied. Respectfully submitted, Joshua and Garrick, on December 21st, 2022. So that's what we call in the industry a very good motion. He's to the point. He lays out the case law. He lays out his argument. Bing, bang, bam, done. Nine pages, including the case captions, the certificate of service, the signature page. So really, the entire argument's contained in under 6.5 pages. It takes Delete Lawz at least double that to say nothing. So if I were to pull my crystal ball out of storage, I'm guessing the court's going to rule along with Josh here. Assuming, once again, I'm assuming that Josh is still a defendant in this case. Because remember, in the supplemental complaint, the court may have been treating that as another amended complaint, and it didn't plead any cases, any causes of action against Kate and Josh, although it did list them as defendants in the header, so in the case caption. So I'm assuming that they're still defendants. If they are no longer still defendants, then it might be dismissed for the personal jurisdiction, 12b1. But other than that, I don't see the claim being kicked for any of these reasons. With that, it's really hot in here. The boiler's on the other side of that wall behind me, so this room's the hottest in the house. So please do all the YouTube likey, subscribey things. Thanks for joining me, and I will see you guys hopefully for at least one more video before Christmas. But if not, have a good one. Thanks.